Hi, I'm Christopher Millard and I lead the Cloud Legal Project at Queen Mary University of London. We are a research team funded by Microsoft and we've been working on the legal implications of cloud computing since 2009. A specific topic that I've been exploring with my colleagues Dave Michaels and Dimitra Cameronou, and you'll meet them both in a moment, concerns the legal status of data stored in the cloud, and in particular, what happens to data after a customer dies? Surveys indicate that 30 to 40% of UK adults use cloud storage services in a personal capacity, though we think that's an underestimate now given the very widespread integration of smartphones and cloud services. And of course, 100% of UK adults will die. So the question of what happens to in-cloud data is relevant to millions of people already, and its significance can only grow. In this brief video, we'll tell you about the research we've done so far, what we've found, and what we aim to investigate and write about in future.
We did. In December 2018, we looked at the standard contracts of 22 cloud services. We picked services commonly used by consumers in the UK. These included storage services like Dropbox and iCloud, email like Gmail, and social networks like Facebook and Instagram.
Now, these contracts are very lengthy documents, and I'm guessing that most of you will have signed up to these services without reading all of the small print. The good news is we have read the contracts, and we can tell you what they say.
So, what did we find? Well, I will give you our top 3 findings. First, most providers do not address postmortem access in the terms of service. In fact, more than 3/4 of the terms of service did not address what happens in the event of a customer's death. Second, password sharing is a breach of contract. All providers had contractual terms that prohibited the customer from sharing their password with others. So, sharing your password is a breach of contract. That could in turn lead to termination by the provider, after which all your data might be deleted. Third, inactivity also carries a risk of termination. 1/3 of the terms of service stated that following a period of inactivity, the service would be terminated, after which, again, all your data might be deleted.
But what about the cloud providers that do address postmortem access in their standard contracts? Well, we've identified 3 approaches. The first approach is to prohibit such access altogether, and simply state that the customer's rights under the contract terminate upon death. And this is the approach taken in the Yahoo Mail standard contract. And Verizon, the company that operates the Yahoo Mail service, has litigated to prevent heirs from accessing data stored in the cloud in the past, as we saw in the Ajamian case in the US in 2017. The second approach is to permit access, but only after the heirs have obtained a court order compelling the provider to do so. And this is the approach that Apple takes for its iCloud service, as illustrated by the Rachel Thompson case in the UK in 2018. Finally, the third approach is that of Facebook, which is to permit access, but only if the customer has left valid instructions, either by using Facebook's legacy contact tool or in a valid will or similar document. This means that if a customer dies without leaving such instructions, Facebook will not give the heirs access. And Facebook has also litigated this point, as illustrated by a case in Germany which reached the Federal Court of Justice in 2018. In sum, we've identified 3 different provider approaches to postmortem access, namely, firstly, to refuse access altogether, secondly, to allow access but only in case of a court order, and finally, to allow access but only if the customer has left valid instructions in a specific form. Unfortunately, All three approaches can leave heirs unable to access customer data stored in the cloud after the customer's death.
So this is an area of legal uncertainty, which can lead to customer hardship. Going forward, we want to focus our research on the specific case in which a cloud provider refuses the customer's heirs or personal representatives access to the data stored in the cloud. Particularly, we're interested in what heirs can do in such cases to obtain access under English law. What are the best legal arguments the heirs can make? And would those arguments hold up in court?
We'll also look at whether English law should change in this respect. In some jurisdictions, there are laws already which allow personal representatives to access data stored in the cloud after a customer's death. For example, many states in the US have a law based on the Revised Uniform Fiduciary Access to Digital Assets Act, or RUFADA. Does the UK need a legislative framework to deal specifically with post-mortem access to digital assets? If so, how should the law seek to balance interests that might be in tension? For example, relating to contractual rights and obligations, property rights, data protection, and privacy. We'll explore these questions and more in our upcoming research paper. Thanks for listening, and watch this space.